So can we start?
Yes,
Okay. A very good afternoon to all. On behalf of Shri Vaishnav Institute of Law, Indore, I welcome all to the webinar on legal aspects of commercial management of intellectual property rights. On this webinar, we have Dr. Vijay Kumar Sri Krishna Chaube, who is professor and head of Department of Law at Sant Gadge Baba Amravati University, Amravati, Maharashtra. I request Dr. Ashutosh Bairagi, principal in charge at SVIL, to introduce and welcome honorable guest and speaker. So,
thank you, Namrata ma'am. A very good afternoon to all of you. Honorable guest and speaker of today's webinar, Dr. Vijay Kumar Sri Krishna Chobe, esteemed patrons of our institute and Shri Vaishnav Trust, respected directors, sir, my dear colleagues and students. I am very delighted to introduce the guest and speaker, Dr. Chobe, to all of you. Dr. Chobe is professor and head of Department of Law, Sant Gadke Baba Amravati University, Amravati, Maharashtra. He is chairman, Board of Studies in Law and member of Academic Council in the Sant Gadke Baba Amravati University. Dr. Chobe is graduate in science, postgraduate in law, postgraduate in arts with English literature, postgraduate in mass communication and journalism, and PhD in law. Dr. Chobe has 18 years of full-time teaching experience and has been working as professor in Department of Law in the Sant Gadge, Amravati University since 2014. He has published 11 books, 17 international articles, and 35 national articles. At present, total 17 students have been awarded PhD under his guidance, and 12 scholars are working for their PhDs. He has entered MAU with several institutions for research work and has been actively engaged in social related work and scheme. Dr. Chobe has completed two research projects, one on farmers' suicide and another on malnutrition. He is visiting faculty of Academic Staff College, HRDC Amravati, Indian Institute of Mass Communication, New Delhi, Maharashtra Judicial Academy, Utthan, Mumbai, and Symbiosis Law School, Hyderabad. He has organized several UGC NET and other examinations in the university as the coordinator of the exam committees. He has worked in committees like State Committee for Cyber Law and Administrative Reforms Committee, etc. I would like to mention here that Sir was the guest of national seminar on cyber law, which was organized in our institute in January 2019. Sir, it's our pleasure to have you with us and hear you again, though it's virtually this time. Thank you for giving us your valuable time. On behalf of all, welcome you, sir, to enlighten us on the topic. We welcome you, sir.
thank you, sir, for introducing the audience with our honorable guest. To know about legal aspects of commercial management of intellectual property rights, I request our honorable guest, Dr. Vijay Kumar Sri Krishna Chaube, to address the audience. Sir, please.
Thank you, Namrata. Thank you, Bairagi sir. At the very outset, let me express my thanks to the Sri Vaishnav Institute of Law, Indore, for extending this opportunity again. And as told by in charge principal of this institute, Bairagi sir, that I had been a resource person in 2019 to the institute, and my experience and my association with that institute at that time was also very good. The atmosphere, the infrastructure was good, and the institute is having really a human sensitive environment. I'm really very much thankful for the director and our mentor, Sri Patnaik ji, for again asking me to let have some interaction with the guest, the faculty members, the students on this very important topic, that is legal aspect of commercial management of intellectual property rights. Now, before I start my deliberation on this important topic, let me tell you few important things. First is that this particular discussion or this interaction I wanted to do from keeping the legal practitioner in in front of me that what is the role of legal practitioner or student of law or researcher or academician or even an advocate towards this IP management and how he can help, because see, IPR is a very big issue and very big industry. Taking for example that suppose you have visited any mall or any commercial place, you can see a simple product. Take for example a soap. Behind that production and consumption of that soap, there are so many big issues are there. Production is there, industries are there, managers are there, intellectual property is also involved in that particular product. Trademark is also there. Sometimes the patent is also on that product is available. Sometimes device design of that product is also very important. Keeping all these things into the mind, the role of advocate is very specific, and to some extent a very specific dimension of that role is required to be taken into consideration. Sometimes when I attend the webinars on IPR, the too much technicality has been involved, telling so many great things about the IPR which generally even advocate can skip, because advocates are generally involved in having some transactions between the parties. Suppose for example, I am having the property just like my home. I wanted to sell it. I am an owner. I wanted to sell that property to somebody. The role of lawyer is to transact between my rights and the rights of the purchaser. Therefore, his role is very specific one with regard to the property. What right I hold on this property and what interest I am having in this property, what money, what appreciation, what payment stages will be there on this transaction between myself and a purchaser, seller, buyer, all these things. The role of advocate is very specific and he must confine to that particular things and must be strategic with regard to that role. The similar aspect is also there with regard to the IPR, that the role of practitioner, role of advocates, role of researcher is very much limited in this particular aspect that I will clarify on the latter part of my presentation. Therefore, these particular things I just wanted to highlight, that this entire interaction is from the legal point of view. Second, try to understand that the IPR, the right IPR is the rights that is fall under the economic law, and it is altogether the different approach than the criminal or any other law, corporate law or other law. The difference is that in criminal law, most of the litigation is from ego point of view. You can just see that fighting between the people or affray or suppose rape, right, offenses against the human body. All these things are happened where the fighting is between the litigation, and therefore the matter has been resolved, dispute gets resolved, justice has been done into the court of law. While with regard to the economic law, people generally wanted to avoid the litigation. Suppose for example, you have prepared, you have produced a very good film, and if there is a stay on this particular film, you will lose the market. People don't want to go into the litigation. They want to avoid the litigation, and therefore in economic, under economic laws, there is a very less, nobody will advise you to go to the court of law, because everybody will put into the laws. Generally those person, and most of the time in economic sector, there is a very less litigation. You can just see that research and development is going on. In movies also, there is a lot of intellectual property right deeds are there between the actor, producer, dancer, singer, any artist are there. You will see very less litigation, because once the litigation start, everything will come to an halt, and the creativity, the production and consumption with regard to that intellectual property product will come to an end. It will be hard, and one type of insecurity has been created into the market with regard to this. Therefore, the IPR, there is a very less litigation is there, and people wanted to avoid it by any means, either by arbitration they wanted to solve their problem, or by any other means they wanted to go for compromise and all those things. Therefore, when I am dealing with this particular IPR, I will less discuss about the remedial aspect, that is okay, criminal remedies are also available under the Copyright Act. Criminal remedies are also available. Breach of violation of your patent rights has been done. There is a remedy available. But people do not generally want to go into the court, and they wanted to resolve their dispute out of the court settlement. Therefore, now limited role of lawyers with regard to IPR, and more profoundly, more important is that with regard to this IPR, more service you need to give to the people who are dealing with this IPR. Means transactional lawyering. Means suppose, for example, I am having a product. Suppose I am having one pen. If I am having patent right on that particular type of refill, that particular type of needle, then that particular says I wanted to sell it into the market, and as much as I want, I can go into the market and grab the market to sell my product. I will have the contract with so many people. I will find out the distributor. I will find the dealer. I will find the sub licensor. I will enter into the assignment with regard to this particular right. Therefore, my more interest into grab more and more market, sell my product, and I need such advocate which will protect my interest. Therefore, with regard to IPR, if you will see those who are giving the service to the IPR sector as a lawyer, they are more advised to transaction lawyering. Means enter into the deed, have certain binding tie-up, certain clauses which will bind both the parties, and therefore more service you can give to the IPR sector by providing this type of things. So I will cover in this interactive session under 5 topics. That 5 topic is, I will just discuss my lecture under 5 topics. First topic I will cover that what is IPR. Generally, most of you may be aware, but if during discussion you wanted to ask, there is no issue. First topic I will cover what is IPR. I will try to distinguish between different type of categories of IPR and how one can distinguish from one category of rights, suppose patent, copyright, trademark, design, geographical indication, then traditional knowledge, so on and so forth. These type of rights. Second, I will just try to cover the emerging trend in IPR, that how this IPR is evolving into this economic scenario, and what are the other aspects are coming up, so that people wanted to interact, and how this IPR is the most important. I will say that it is the oil of 21st century. It is very important things in 21st century, and IPR is really changing the entire scenario of the society, basically the economic sector of the nation as well as industries. Third point, I will try to cover the commercial exploitation of IPR and what are the important aspects that one need to keep into consideration, that what are the commercial exploitation of IPR, how law can assist it, how commercial exploitation actually takes place, and how you can help this particular commercial exploitation of any IPR product. Then how the commercial management and policy approach for IPM, means intellectual property management. And last and most important, I think that crux of this particular presentation, that legal aspect involved in commercial management of IPR. And last, we will reserve some time for the discussion. Meanwhile, if anybody is having any issue, he can raise at any moment of time. This is an interactive session, and we are just interacting with each other. Any doubt can be clarified any moment of time. Okay. Now, basically, I just wanted to discuss about this IPR, what exactly the IPR is. So IPR, as you are aware, people, this is one kind of property right that has been emerged during the course of time. A lot of things you have already studied upon, but initially this IPR is an umbrella term. It include in its the several type of different legislation. For example, the Copyright Act, which were having its own history of evolution. Copyright generally, as seems that it has been evolved. The first basic right was the Statutes of Anne 1709 that was bring into force in UK. Then there are these all right. Copyright Act is there, patent is there, trademark is there, design is there, semiconductor and layout design is also there. In some jurisdiction, the plant breeders' right are also considered. Innovative patent is there, traditional knowledge is there, so on and so forth. Even sometimes we can say that traditional knowledge is also considered. Geographical indication is also one kind of right under this IPR term, and most important, trade secret is also one type of intellectual property. So IPR is an intangible right that is created by labor, skill and judgment and having the economic value. That is, in short, we can say more profound definition has been given on World Trade Organization website that intellectual property rights are the rights given to a person for his creation of his mind, usually give the creators an exclusive right, means that monopolistic right over the use of his creation for the certain period of time. So therefore, this intellectual property rights, it is having some few very differentiable things than our property rights. The other property, which is the tangible property, movable or immovable, has been governed by some different legislation, and this intellectual property right, which is intangible, you cannot touch it, created by labor, skill and judgment, and it is having the day of its origin and end of its right. Therefore, so far as time is concerned, IPR is a limited right except trademark. All IPR is a limited one and it ends with certain time duration. For example, patent is having in India 20 years duration. Copyright in some cases is having 60-year duration. In some cases having 50-year duration. Design at 10 years extendable by 5. Trademark throughout, when up to the time you wanted to use that trademark, you can hold the right over the trademark. Therefore, except trademark, all other rights are given for a limited period of time. Certain rights are required to be registered, certain rights, certain IPR is not required to be registered. Registration, they are by default protected under the law. Now, when we discuss about this IPR, very few things you must take into consideration. This IPR is a very different because it is a very volatile in nature. Volatile means your property, house property is having certain demarcation and nobody can steal it. Even suppose, for example, you are having a car, it is having some physical tangible limits and therefore nobody can make a certain copies of your car and sell it out and use it. But suppose, for example, you are having a book, anybody can nowadays make a copy of that book, sell that book, make its value lower down, devaluate it and sell into the market. If you are having any good painting, anybody can take a multiple copy and distribute it to the 1,000 different destinations. Therefore, so far as IPR is concerned, which is having certain value, economic value into the market, is capable to multiply, use it, send through the air and send it to the 1,000 destination throughout the geographical locations, and you may not have control over it. Therefore, whatever the basic control you are having over your real estate property, that may not be available in the with regard to the IPR, because now most of the IPR is having digital format and therefore this can be passed on through the air, through the various wire, and you can just sell that particular product, steal that, make copies and taken from you and sent to the several destinations. Therefore, in this regard, the IPR is very sensitive and can become the very volatile and taken out from the owner and used by any person. And there are various incidents. Even Amazon, they have lost, huge loss has been done to the Amazon when somebody has copied the thousands of books from their server and send it to the several people without any cost. The same thing you can just see that when new movies come, the pirated version of that movies come into the market, and the producer or the owner of that movie how to sustain the loss and lose the market and how to lose his royalty on that particular movies. And therefore, with regard to other property, there may be some control you can enjoy, but very less control you can enjoy. Only the protection that you are having at initial level is with you. Once it is moved out of your hand, it is put to the several risks and then it is possible. Therefore, some specific type of protection is required with regard to the IPR. That is, you must have certain various that we will just see in the last button slide of my presentation. So then second point is that with regard to this IPR, more important thing is that when you are discussing about this IPR is possible to be utilized in different format, no doubt about it. But all the jurisdiction, the Indian jurisdiction, the Western countries, every jurisdiction is having the different legislation for this intellectual property right, except copyright, because under the Berne Convention in 1886, there are certain uniformity with regard to this copyright, but industrial property, that is patent, trademark, design, and all this, they are having different type of litigation, laws, protection, their practices are different. Therefore, so far as patent is concerned, you are having different legislation for patent in India, different patent law for UK, different patent law for Pakistan, different patent law for America, and therefore all these law differ according to their jurisdiction, and therefore that is to be kept in mind that though IPR is based on certain principle, the procedure, the practice, the methodology in all the jurisdiction is different, and therefore while giving the advice to the client, you must also know certain rules and regulation about the jurisdiction. In short, I will just discuss. If you are having any doubt, you can just ask me. I will just discuss few important aspects of all these categories of right. First is that with regard to the copyright, as you are aware, section 13 of the copyright speaks about that copyright subsists into the 6 categories, that is the literary work, dramatical work, artistic work, musical work, cinematography work, and sound recording. And it is subsist in all these 6 categories. And then if you are a creator, if you are the original creator, you are treated as an author, painter, artist, whatever it may be, producer or composer. And then these particular things you can assign to somebody, and you can sell it out also. You can license this particular right that is given under section 29, 30s and all those things. Some remedial aspect has been given in later part of this particular. What exactly the copyright is? Copyright protect the expression, what you express. It is the expression, original expression. What is original expression? That comes from you, not copied by anybody. The condition of originality that is given under the Copyright Act means it must come from you. Suppose, for example, you have written any poem, the words that you use, the composition or the combination of word that you use must be original, and it must be of your own one. You may twist the idea taken by any other person. You can be inspired by any poem on patriotism by anybody, but expression and wordings must be yours, and it will be treated as original expression of your, when it can be differentiated by other party. For example, one test has been developed by the court, lay observer test. You are aware that in tort, the prudent man test has been developed by the court. Under Copyright Act, the lay observer test has been developed. That means that if the common man moving on the road, if he listens certain music composed by any film producer or any sound composer, and the same music, if he feel that when you are composing the one is inspired and he is having the idea that this particular thing, this song is appear to be very much similar of that another song, then the test of lay observer will fulfill, and it will be treated that you have copied that particular things from somebody. For example, if you listen parody songs, you will easily understand that original song is something different, and the person who is singing the song by different words only but having the composition same one are treated as the violation of copyright. Therefore, when you are expressing something, words, composition, style, labor, judgment of arranging those words must be from your own. But it does not mean that the ideas must be original, because see, on patriotism, one cannot say that he has entirely patentized or monopolized that area. If somebody has written poem on patriotism, Thousands of people can write a poem on patriotism, only their difference must be of wordings, of composition, of feeling, of approach, or how they express their feeling on the patriotism. Somebody may be have sort of different tone, somebody may have very harsh tone, and all those things are different, may be feel by the lay observer. And in that case, if lay observer test has been satisfied, that just two different things does not appear to become from the same one, it is not supposed to be copied. Lay observer test has been developed, if you wanted to note down, in R.G. Anand versus Deluxe Telecom Limited by Supreme Court in 1978. This is very important case. Rather, I feel that in that case was not very good one, because that case was based on the earlier act, 1911 act, and it was not based on the litigation and dispute that was arises in 1956 between R.G. Anand and Deluxe Telecom Limited. But the Justice Pathak has developed this lay observer test, and it is still find good in India, though in foreign countries the feel and observe other tests has been developed and they are found to be more suitable and scientific one. But in India, still lay observer test is supposed to be stand good. So copyright, in short, protect your expression. Important point with regard to the copyright is that it does not need registration. In fact, default registration has been considered. Means if you created one, if you are writing a poem, if you write down one stanza, that is itself by default protection is available. No need to go for registration. If you do not register, there is no any problem. Only thing is that you must have document to prove that it is your original one. Therefore, if somebody is writing a diary, if he is having a habit to write a diary, that diary itself do not register, and even during the lifetime of person, that diary was not known to any person, it was still having the copyright protection. If you are writing something even on the desk benches, because most of the law student, very good law student, are sitting on the last benches and having very creative mind, that is also protected. Some people are using the right to write, having habit to write on the wall, that is also protected. And this right of an author which he has created is protected anywhere, irrespective of registration. Therefore, for copyright, there was no need for default registration. If you do not register, there is hardly any different lies. But registration is advisable under Copyright Act, because only one reason. What is that reason? You are aware that there are certain remedies available under the civil laws. For example, if you go into the court of law, or suppose somebody has taken your property, stolen your car, and you find that particular person has caught by police, and that particular car has been recovered. If you went into the court and court said that, okay, after the litigation will over, we will pass the judgment with regard to the ownership of car. This litigation may take 3 or 4 years. Till that time, you are not able to enjoy your car. What remedy do you need? You may immediately require the remedy that court may pass an interim order to give your car to yourself. In the same in copyright, suppose for example, I have written or I have created one very good song that is into one particular movie. This type of song was there into the Agnipath, second part of the Agnipath. In that particular movie, one song was sung and that the dispute was arises. If suppose for example, you enter into the court and want an immediate stay, court need 3 things to get fulfilled. One is that there must be a prima facie case in favor of you. Second is that irreparable loss will be there, and third is that the balance of conveniences lies into your favor. So prima facie case will be there only in case if you are having registered document in your favor. Otherwise, you have to prove that you are the owner, and it will take a long time to prove that really you are the creator of that poem. Therefore, if you registered your product, it will help you in the initial battle of the litigation itself to get injunction in your favor to prove that the prima facie case lies in your favor. That is the only difference lies of the registration. Same thing is with regard to the trademark also. When trademark either may be registered, may not be registered, registration of trademark is not mandatory. And if you are having unregistered trademark, that is also a very good trademark. But if you are having registered trademark, you can initially prove that the balance of convenience and prima facie case lies in your favor, and you will immediately get injunction, and court will get convinced that yes, prima facie it appears that it is your creation. And if you do not register, the court will have not any clue to find out, and it will altogether become the matter of fact to prove in the latter part of the litigation. Therefore, registration is advisable, though not mandatory, both in case of a copyright and trademark. Second, the copyright is there. Copyright is having 6 particular things. Literally, literature, as you know, then it is a dramatical work. The copyright subsists. Third is that musical work. Fourth is that artistic work. Fifth is sound recording, and sixth is cinematography work. Now, I just wanted to tell you, just this is the right time to tell you, if anybody wanted to know that how the contract that is important with regard to this entire IP matter, go to the section 17 of the Copyright Act. The section 17 of Copyright Act make your point very clear that if you are having prior contract into existence and it is not contrary to the basic principle of contract, that contract will prevail over the entire copyright material. I will just clarify these things. Suppose, for example, I am a painter, I am a creator, I am an artist person. I know the art, and I used to prepare very good painting. Now I can paint something and I can sell it to the art galleries. In that case, when I sell that particular things, I will sell all the copyright except my moral right into that painting to somebody. Now, suppose, for example, instead of that, one particular businessman called me at his home and he says, okay, I will pay you. Suppose you need 3 days for painting or 10 days for painting, I will pay you. I will pay you your remuneration and just paint something for me. I will provide you facilities. I will provide whatever you want, and you just paint a painting. In that case, the prior contract exists between myself and businessman, and whatever I will create will goes to that businessman. The same thing is with regard to the camera person who come to take photograph of your birthday party. Your son's birthday party is going on. You called any photographer, pay him for photograph. Now, as you have already paid that photographer, all the intellectual property right into the photograph lies with you because you are the owner. Though he is a creator, you are an owner. Therefore, if prior contract exists between the person who is a creator and who is the owner, this contract will prevail. Try to understand why. Suppose, for example, I am a scientist, but I am working into the laboratory of some company. There is a prior contract of service exists, and therefore whatever I am creating, except moral right of carrying my name to that intellectual property right, all other right with regard to that intellectual property lies with an owner. So you have to understand that if you are having good contract, well-defined contract, you can hold, you can become the good owner of this IP creation, and you can hold the entire right on that except the moral right into the intellectual property right. Therefore, if you are a good advocate and you know how to better interest of your client can be served, if you are giving the good advice to your company, if you are an advocate for any company who is dealing with intellectual property right, you have to safeguard this right at the initial point so that company can hold entire intellectual property right with its own. Means, suppose, for example, a day after one very good medicine has been created. Now, if there is no good contract between the creator of that medicine, for example, scientist, and that company lies, the employer can misuse this particular loopholes into the contract and enjoy and run away and make his own medicine into the market by giving dodge to the company. and main is controlling this behavior or conduct of the person. You must be able to draft a good company contract, good employer-employee contract, good contract which will regulate the relationship between the person who is holding copyright and who is the owner of Copyright Act. Therefore, the role of advocate in this entire scenario is to understand the technicality of intellectual property right and then safeguarding the interest of both the parties. Means all other parties who are involved, seller may be there, then distributor may be there. If you are a trademark mistake, for example, I will give you one example of this coffee. Now, coffee is the second most traded commodity across the world after oil. As estimated, around 1% consume 400 cup of coffee a year. Now, suppose for example, if that much coffee has been distributed throughout the world and it has been prepared into the Ethiopia, good coffee is there into the Ethiopia. Now, if this particular right you wanted to advise to these people at Ethiopia, now what intellectual property lawyer will advise? Intellectual property right will first advise to the company who wanted to have the good brand of coffee, which wanted to have the good varieties of coffee. The company wanted to have the good trademark for them. Company wanted to have the protection into the geographical indication of that particular land. The advocate must be in position to advise them how to protect their right of preparing the varieties, good varieties, plant varieties of coffee, having the good brand name for that particular coffee, distributing it, and making the people bind by all these clauses, which is very essential into the market, so that nobody should make deceptive trademark, a deceptive product according to the as of that company, and make violate the right of that particular company. So our role as an advocate is to protect the person who is the owner of copyright or owner of patent or owner of trademark or owner of design. So your role is a limited one and you have to think from that point of view. Again, coming back to my own point, is first I have tried to describe the copyright. If you are having the issue with regard to copyright, you can just ask right now also. Now the trademark, generally trademark protect the mark which is capable of graphically representation, and again it can be differentiate the product of one person from another. Generally in India, the word graphical representation is very now the term, because there are sometimes the sound that is also capable to distinguish the product. For example, you make your laptop on, you can listen a specific sound and you can just differentiate that particular sound of that operational software of Indore or something what you are using. Sometimes even some ringtone is also differentiate the product of one company from another. Therefore, even the sound which is may not be sometimes graphically, or even the smell. Suppose, for example, one company that is preparing the tennis ball is having the specific smell of cutting grass. That cutting grass smell is very peculiar quality of that particular product, that tennis ball, and that was also protected in England. But in India, the mark to be a trademark must be capable of graphical representation, and second is must be capable to distinguish from the product of another person. This is the mark. This mark does not have more categorically defined into the this particular things. But whenever you are dealing with the trademark is a such mark which distinguish the product of one particular company or proprietor from that of another. Therefore, if you are capable to distinguish two different products with the help of that mark, then you can regularly realize that that particular trademark has been used as a mark into the market by that proprietor. And as I have already told, there is no need for prior registration of that mark. Definitely that mark should not be unethical or immoral one, but you can use any mark which is maybe capable to sometime misleading one. For example, nano. Now nano, this word is having some specific meaning. Then quality, for ice cream, quality word is also suggestive one particular thing. clinic for shampoo, it is also suggestive of something. Kurkure, it is also one quality of suggesting some type of food or crunchy food or something like that. Therefore, you can use any word and not prohibit it. But when you go for registration, the trademark registry will oppose you from registration, because if there is a suggestion involved in an art or some suggestive nature of that quality is there, then they will won't allow you to register that trademark unless after 5 to 6 years of continuous sale, you are capable to say that now your product and your name and your mark is now capable to distinguish now. And if somebody use the word kurkure, the people realize that this particular kurkure stand for specific mark, specific trademark for one product. Same things that with clinic plus means now people are realizing that clinic plus is not a stand for any clinic, but it is stand for a name of shampoo. When you are capable, once you are reached to the stage that your product is capable to get distinguished by that name or mark from the product of other, you are capable to be registered. And therefore, the people generally want to use such type of suggestive name, because in market, people recall that name more instantly. For example, Ultratech, it is the combination of two words, ultra plus tech. Ultra means superior, tech means technology, and the cement company is using that particular name. Why they are prone or why they are tempted to use such a name is because they want that the word must be very much suggestive to the people. Later on, after 5 to 6 years, they will acquire the uniqueness of that particular name to their mark, and then they will go for registration. Therefore, if the company have been given the choice to use very unique name, which is sometimes very difficult to remember, or use such name which is very familiar to the people but not capable to be get registered, company will choose the second one, because they wanted that people must keep into their memory their name, which is very general to be remembered, because this will secure the market. Because good name, generally the name that is recalled very easily or keep into the mind of the people. Trademark, that is very essential. And by advertisement also, you wanted to keep bombarding to the mind of the people and make your word familiar into the mind of the people, because you wanted to secure the market. Therefore, even this is a strategic decision with regard to the trademark, that you must use such mark which may be capably keep into the mind of the people. Because how the product had been sold at the doorstep of any shop is that when people reach to the shop, they ask the product, and they ask such product which is they can remember, recall at least. Suppose, for example, you go into the shop and you wanted give one shampoo that is one sunsilk like that, and you just remember that particular things. If you have heard that name on TV, weeks or like that, you will ask that product, irrespective of whether that product is very qualitative or not. But because you know the name of that product, you prefer to buy that product. This is what generally the technique is, and therefore in trademark, people used to advise such type of trademark. Therefore, if proprietor want you to advise whether Ultratech is good word or bad word, you must think from that point of action, because it is more important to grab the market rather than giving the technical evidence that what law suggests not, because law only need that your mark must be unique one, and that uniqueness you will capable to acquire after 5 to 6 years, and you can go for registration after 5 to 6 years. Show them that your sale is this one, and you are really having the good name into the market, and now people are capable to distinguish your product from your from others product, and therefore you are capable. Same thing is with regard to the registration. If registered trademark is there, it is only capable to get injunctive remedy, and if you are owner, proprietor of the unregistered trademark, still you are capable to get passing of remedy, that is given under section 29 of the Trademark Act. And only thing is that after the litigation, after the account of profit and all those things, you will capable to recover the money that has been wrongly get by your competitor into the market. Therefore, this is what about the Trademark. Trademark can be distinguished. It is a mark. It is capable. Suppose, for example, you can be aware about Coca-Cola. Remember that Coca-Cola. Remember the Tata company mark. Remember the Suzuki. M for Maruti, and so on and so forth. Bajaj, R for Reliance, all those things are there which distinguish. And once you notice that particular trademark, you are capable to distinguish that particular product. And it is really a good thing that product must have certain mark, because sometimes you may be aware that in market the wrappers are available in the plain polythene bag without any mark, without the name of any company. That is also not good into the market, because by having the trademark, it serves several purposes. It will not only tell you that where from that market that product come, but it also hold the legal responsibility of that trademark owner to defend his product. Sometimes it is possible that you can just have the claim on that particular product, and you need the person to be claimed the remedies from that. In that case also, into the market, you need the proprietor, the origin of the product, and where from it has been manufactured and produced, and who is the owner of that trademark, and you can get a remedy. Therefore, trademark not only serve the purpose of distinguishing the product, but it also help to, I can say, help you to understand how these particular things can be get differentiated. And in the time scale, the proprietor also take a lot of pains to develop the reputation of his product, and therefore he always try to make his product more qualitative, and the trust of the people may lies into the product. That is also one equation that work into the market. Therefore, if any product is got a good quality, for example, Raymond, no any person, no even the proprietor dare to play with the reputation of that product. That is very important. So this is what the trademark. And from legal point of view, for a practitioner, he must understand the market reality so that he can advise. See, in trademark, there are several scope is also there, because if I am producer of one particular product, I am the producer, but my product will be sold into only one jurisdiction and people don't know. In that case, I will not able to grab more market. I wanted to sell the product throughout India. I wanted to grab the market. In that case, I wanted to reach to more and more people. I need more distributor. I need more licensor. I will need more sub licensor. Say for example, Patanjali. You can see that the Patanjali, when it has been got expanded, earlier their company lies only near the Haridwar in Uttarakhand. But afterward, when they are manufacturing at different places, they are manufacturing this product. They have given this particular sub licensing to the different owner of different companies, and they are producing that particular product and selling that things. Similarly, of the Coca-Cola plant, they are having the bottling plant at different places. So if you wanted to grab more market, you have to engage with other people, and that engagement can only be done with the contract act. The contract between the two parties, for example, owner of the IPR and the person who wanted to be associated with him to sell his product, to grab that, to purchase that intellectual property, always have some contractual obligation, and that contract can only be prepared by the legal practitioner. Therefore, how the legal practitioner can help in this entire business of production and consumption of the intellectual property will really tell you what important role of lawyer is. Lawyer may not be much more aware about the technicality of the product. Suppose, for example, now the vaccine are there. You may not be aware that what is the content of vaccine, but you must be aware that how the best interest of your company can be protected into the market, how to enter into the licensing, because once you are having one vaccine, you have to enter into several jurisdictions for production, for distribution, for licensing, for selling, for sub-licensing, grabbing separate market. And that is not the business of one person to run entire market. There are several people you require. For one particular patented product, at least more than 10,000 contracts are required to be entered into with regard to several things. For technological adoptions, suppose you have prepared very good lanes. you are selling that lens to one particular company, selling that same technology to the several other company of the mobile, then that company will also sub-license, enter into sub-license with several other people. And this type of services are provided by the lawyers. Therefore, in company, the next position after the manager is of that legal advisor who are keeping close watch on the interest of the company and help the company to have the commercial exploitation of that product. And by that way, you are helping that company to use that intellectual property right with the very best manner so that the interest of the company can be protected. The third one, that design is there. Definitely, what lies in design? I will just tell you, after trademark, design is the oldest one in which the people or society was having the great interest. Remember the history in which the new design of the ornaments were very important and it differentiate the importance of the people. Even today, in jewelry, several type of design is there. Design is too much important even with regard to the cars also, which is having the aerodynamic shape. Design is also very important with regard to the product, with regard to the mouse you hold into your hand, how it has been there and how easily it can be operated. Therefore, design after the product, it is more important how design is. If design is good, you can see that. Just go into the mall and see the different shape of the shampoo bottles. You will see that the different shape of that shampoo bottle helps sometimes to have the very ornamental shape. Sometimes it is very stable one. Sometimes it is help you to have the very better look. All these things are there. Sorry. So the design is very important things with regard to the product, and though it is having certain outer look, it is sometimes it is very important to give the different purpose to that particular product also. And design is not only important with regard to the only few product, ornamental or other industries. Design is almost all important with regard to the any field now. It is very important one. Even suppose, for example, shape of any particular product that you can see, it serves a certain purpose, and design help to distinguish that particular product, capable of doing some specific feature to that particular things. So under Design Act also, the particular person may get 10-year protection initially, and after second time he will able to get a 5-year protection also. So design is capable. Design Act protect the design. It is one kind of copyright, extension of copyright only, but design, because it is its specific nature, we cannot consider sometimes it as a expression of something. Therefore, design, though it is very much similar to the Copyright Act, but design itself is having its own different legislation, and some different feature is there. Therefore, Design Act help to have design of industrial design is having some specific design and capable to get protected under the Design Act 2000. And then there are certain other important but not very much prominent act also, which also protect Copyright Act, for example, IPR, for example. Geographical indication, it is associated with the specific quality of one product that is associated with a geographical location. For example, Kanchivaram in India, or suppose there are several things are there which is associated. Champagne, this word came itself from some geographical location for this champagne. It is one particular thing. Even the Assam tea, the specific quality, specific nature. Even for example, you may be aware that there are certain product which is known from their from the location where from it comes, and therefore due to that geographical location, government come up with specific legislation of Geographical Indication Act. There are some other things also. You may be aware, traditional knowledge is there. Traditional knowledge have the negative type of knowledge. If you are having the traditional knowledge, everybody can use it, and that knowledge is required to be get documented, and you can just use that knowledge, and the other copyright or patent or trademark, nobody can use that particular thing. Suppose, for example, you are aware that in turmeric, in India, turmeric was used as an antifungal and antibacterial drug. And in America, the attempt was made to get registered it for the same quality. So if traditional knowledge tell you that this was known quality to the people, the patent cannot be granted for that particular things. The same thing is with regard to basmati, that was the known species of rice. Then there is a semiconductor act, layout design is there. Some type of other rights are also available, though in India, the utility patent was not granted, or innovative patent, that term is not there. In Australia, innovative patent has been granted and standard patent has been granted to more advanced knowledge or more advanced utility or novelty, and all those things are there. In India, utility patent and innovation patent has not been granted. We only grant the patent itself. Then there is some other category. For example, plant breeders' right. Plant breeders' right means that is a separate legislation in India. Though such type of legislation was included under Patent Act in other countries. Plant breeders' right means this agricultural people prepare certain varieties by research and by nowadays various seeds company, they are preparing their rights. You may be aware that certain seeds, certain kind of processed seed give better product to give better yield, less water consumption, and more protection provided against the diseases and all those things. This type of plant breeders' right for species, innovative species, has also been granted. Some rights can also be treated as IP rights under Biodiversity Act also, and so on and so forth. So IPR in general, as we are told and we have been taught under several legislation, that IPR is such a terminology where the rights are available by legislation. The registration sometimes is required. Sorry, I think that I have skipped Patent Act. I will just tell in short what Patent Act is. You are aware that patent is definitely granted to the ideas or such things which involve three things, that it is a novel one. If you show that your invention, it's totally new, not known to anybody, totally new, novel, and not known to anybody earlier, and that is non-obvious also and cannot be guessed by any person skilled in the art. It is not guessed by him. And third, that it is having industrial application and utility into the market. Such type of invention, and if that type of invention is not prohibited to be get patented by Section 3 of the Patent Act, such invention is capable to be get patent. So patent is such a type of right which is required to be get compulsory registration. And patent, what type of patent has been granted? Invention that fulfill three conditions. It must be novel, it should not be non-obvious, it should be non-obvious, and third, it must have the industrial application. If any patent clarify this particular condition, then we can say that this particular product is capable, this invention is capable to get patented. In India, Patent Act 1917 govern this particular things, and Section 3 negatively clarifies that what is not patentable. All invention is patentable except those given in Section 3. If any invention fall into the category of Section 3 of the Patent Act, cannot be get patented. Means Section 3 first says that if it is frivolous, means it does not capable to be exist at all. Only manipulation of things are there. Then such type of patent is not capable to be get patented. If immoral patent is there, you have created such particular machine which is fraudly deceive, and it will capable to be suppose for example such a things which is totally an immoral things, then in that case such invention is not capable to be get patented, and so on and so forth. Suppose for example medicine, there are Section 3 to 16 categories are there in which the patent inventions is not capable to be get patented. Even you are aware that Novartis, that famous case Novartis versus Union of India, in which the company wanted to patentize the drugs which is supposed to be the attempt of evergreening of patent. Means what they are doing, they are having one drug earlier patented by them, Gleevec drug, imatinib mesylate, and now after 7 years they come up with the similar drug only the mirror image of that drug, saying that this is a different drug. Therefore, the objection has been taken and patent office rejected their claim, saying that it is merely the rearrangement of a particular thing. Section 3D of the Patent Act has been violated. Therefore, this invention, which is frivolous in nature, which is only tell about the same thing, evergreening of patent, already known product in different format, mirror image, you are coming up with, it is not capable to be patented, and patent has been rejected on the immaterial mesylate mirror image of the blue drug that was already patented by the Novartis drug well before. So this type of patent is there. Patent Act in India is provided protection for 20 years. It required that there must be a provisional specification must be filed. And one thing is that novel, lot of things can be told about the novel means not known earlier. Not known earlier does not mean it exists earlier. If you are discovering such thing which is not known to the people but that do exist, for example, neem plant, we are aware about the antibacterial qualities of neem plant as a directa indica. In India, neem plant has been used as antibacterial things, and we are using the particular things, though we are not able to know the chemical formula and chemical reaction, chemical process of those things. But the in-house, you may be aware that the small kids, small infant is used to be kicked into the leaves of the neem plant. So people are aware about this, though they are not aware about the chemical process or chemical composition or chemical technicality of all those things. So if you are aware, means not known but aware about the particular things, you are not having the exact knowledge of something, this such things are also not capable to be get patentized. Similar things is about the traditional knowledge in rural and in particularly tribal people. Lot of traditional knowledge is there. They are using so many plants, so many techniques to get eradicate their disease, fight with disease. Even in Ayurveda, even in olden days, our grandma was knowing so many such techniques are there which can help to fight with the disease. Such things are there. Therefore, patent is not capable if it is not novel. It must be new, not known to anybody earlier, and it must be non-obvious and having a capable of industrial application. This is what a few discussion we can just make about the intellectual property rights. Intellectual property rights, all these things are telling, means this particular intellectual property rights are there. This is what the first part of my presentation is. The intellectual property right lies in this particular thing and this. Now, for violation of this, suppose for example, now second point, what emerging trend in IPR? Now you have to be very much careful to understand that when we are discussing about this intellectual property right, emerging trend is like that with regard to the copyright or with regard to patent, with regard to trademark. CTEC, for example, if you have invented very good one things, I will just tell you with example. Suppose, for example, we are having dissertation at our master level. Now, every year, hundreds of people used to prepare their dissertation and submit it for evaluation to the institutions and get their mark and get their dissertation evaluated, and they submit their all these things. Though this dissertation is capable of getting access and getting marks, or even it is copyrightable, but it is not very much useful unless and until it is having the market value and good things into the market to get sold out. Means, suppose for example, you are submitting your dissertation in suppose chemical technology, and this particular dissertation contains such a good research work which is capable to be have evolved good medicine, then such type of dissertation is really worth one. Now this dissertation is really having certain good things value into the market. Therefore, so far as so good, IPR, thousands and crores of pages types of IPR is usually created into the market, but very few are capable to be get exploited into the market. For example, if you see the patent filed into the India, only 2 to 3% patents are working patent in India. That can be seen on the basis of renewal fees paid by them. After 2 to 4 years, Nobody pays the renewal fees because that patent is not workable, and therefore the person holding the patent is not even able to pay the renewal fees also. If patent are working, then the people will definitely afford to pay the renewal fees. The same things you can just collect the data from the website of patent and controller of patent, trademark and design, that how many patent are alive today. Hardly 2 or 3%. Therefore, if suppose, for example, your research, your literary work, your design, your trademark is worth capable, your product itself is having the good content, that particular product is sellable into the market. For advocates, they must understand that what are the product, what are the commercial value of that particular product, and how that can be protected. Therefore, for advocate, they must be very much strategic to know that what are the valuable product, what is the valuable IPR into the market, and how they can associate, interact, or commercial tie-up with other people. That manager will be, or that company will decide to whom they wanted to go. But advocate have to advise that how they can associate it with other people, how they can get the market, how they can protect their product into the different market. India, so far as IPR is concerned, for example, pharmaceutical product is concerned, India was supposed to be the such place where most of the product are taken the IPR from the American company, and here we prepared such product which is actually not patented in India due to the specific conditions laid down into the Patent Act, and therefore we prepared such product which is very much similar, that is called as a pharma piracy or biopiracy, or any such words are there, smuggling of technology and preparing it into different jurisdiction. Therefore, for advocates, they must be aware about this specific problem with associated with the IPR, and they must know that this type of things are there. When company go for commercialization, we will take one example. Suppose one lens, very peculiar lens, has been prepared by any scientist. Definitely, scientist is not capable to pour that much money for production and consumption at market level or at global level. That is not possible for him because he is not expertise in that area. Now, how advocate protect this type of interest? When the scientist itself is preparing any product, the advocate or any practitioner can advise him that if he wanted to prepare some IP product, the protection begins from the zero level. Suppose you are preparing any pharmaceutical drug, you must be aware that this information of preparation of drugs should not go out of the laboratory, so that nobody should smuggle your knowledge to third party. So advocate can prepare such a documentation where he can possibly defend in case that yes, this product has been prepared by them. If somebody visit the laboratory, they must sign the non-disclosure agreement. In absence of non-disclosure agreement, you cannot prove that the person visited your laboratory and taken the knowledge outside and sell your knowledge to the competitor. Your employee who are working with them should not leave your job at the level of final stage of your product preparation and associate with your competitor and prepare the same drug. You should also tie up your employee and those scientists and all those things. So work of advocate start from the beginning of the production or even the birth of the IPR product. So suppose, for example, in Shri Vaishnav Institute of Law, suppose, for example, you are having any laboratory, so your employee must have some liability to have the association with the institute to share their intellectual property if that has been prepared, produced at the institutional platform. If the teachers are there, they are using the platform of the institutions. The product that has been created with the help of institutional platform must have the institutional legacy or institutional right over that particular things, though the royalty can be shared between these things are there. Therefore, even prior to preparation, production of the IPR product, the role of advocate or legal advisor starts, because they are though not into the production or real preparation of the IP product, but they help to fence, to keep boundaries around that particular product. They can safeguard the creation, they can safeguard the protection at initial level. And once this product has been prepared at the final stage of submission to the authority, the advocate may be in position to advise them that what are the better option, what are the better choice for the owner of the product. For example, you may be aware that this Coca-Cola, the taste of Coca-Cola is very unique one. If Coca-Cola wanted to get the their product registered on the Brewerage Act, they must disclose the content of that particular product. Now, once they disclose that content of their product before the authority, they may be capable to get 7-year protection. But by keeping this knowledge, information secret one, they did not disclose this information before the authority and opted for trade secret. And from 20 years, no any competitor is capable to produce the Coca-Cola and its product and duplicate one, because they are capably kept their product trade secret one. So if suppose you feel that you do not want a patent but want to go for trade secret, then you can opt for trade secret if you are capable, that you feel that even after 20 years, even after 40, 50 years, nobody is capable to make your product by reverse engineering. Therefore, under which law you wanted to register, that is also the strategic decision of the advocate, that under which law you wanted to go, whether to go for registration of trademark or don't go for registration and opt for good business, and afterward, after 5 to 6 years, you wanted to go for registration. That is a very good decision advice given by the advocate to the company. So here our skill of advocacy lies, that what type of advice do you share with your proprietor. Again, once the product has been completed, now formality of registration, non-registration, going for trade secret, applying for different offices under different jurisdiction, under patent and cooperation treaty, all these things are the strategic advice that legal advisor can give to the company, and they can protect their product. But more important for advocate is that their business lies in that. If we compare that where the IPR is more strong, IP, intellectual property, is more strong into the market. And here you are just trying to understand that, suppose I have prepared one particular movie, for example, Bahubali, and I am a owner, I am a producer of this Bahubali. Once if I am passing through a road, I observed that one particular man sitting on the footpath is selling the pirated CD of my movie. Whether I should go for remedies and seize all the CDs, or file a complaint against him into the local session court, definitely my advocate will advise not to file a single thing into the court, because that particular person is on the footpath itself. I have to pay, I have to bear around 50,000 for litigation, and I will get hardly, once that particular man get arrested, somebody else will start selling a CD. Therefore, here I have to understand that whether I should opt for litigation or not. And definitely sometimes the advocate advise the company that better avoid the litigation to save your product to time, because the litigation will kill your time, money, and all those things, and in return you are only capable to put that person into the jail, which is not profitable for the company to spend 50,000 or more for that particular litigation, and such type of people are there. Therefore, economic law, more importantly, the IPR is a strategic one. Here advocates know the ground reality, the market reality. They know how the clauses should be prepared. Commercial exploitation of product is more important. I will give another example. See, for example, Suppose I am preparing the potato wrappers, and suppose, for example, I am having company or one particular unit at Nagpur itself. I am preparing it, suppose Haldiram, that product is there, I am holding that particular company. If somebody wanted to, in Madhya Pradesh, wanted to similar type of product, there is a two possibility that he may have to start his own business of preparation of potato chips and grab the market, or he may tie up with the Haldiram and take his product, his trademark, his technology, everything, and start business by pouring the money. Now, if suppose, for example, he get a name, known name into the market, purchase it by license, then sometime it is more profitable to him. He has to only put the initial money, but already set up name, already all these things he will grab in position, and by that way, the Haldiram will able to extend their business in Madhya Pradesh and so on and so on. Such type of deed, such type of licensing is the main business of advocate, where advocate can advise their company to have the IPR, to hold that particular IPR, to play that, transact with that IPR, and here the clauses of all those things will lie. So in commercial market, the legal aspect you must be capable to be taken into account is that in what way you can protect the product IPR. Here you may not know the more content of what is the basic copyright, what are the things that lies into the copyright. Few very general things you must know, but you so that further litigation, further complication can be avoided. So with regard to IPR, the best any legal practitioner can do is he must develop the mastery of drafting and just jogging down the main controlling point of conduct of each party. Suppose, for example, you are selling or you are appointing the distributor for your trademark, you are allowing or licensing or assigning your trademark to any other person in different jurisdiction. What are the ramifications? How that person will respect your trademark, how he will not support the competitor, how you can keep that person away from your competitor and his product to be get sold, how he will protect the interest of your in that particular jurisdiction, what kind of royalty he will pay, what would be the time, and even if unavoidable dispute would arises, how you can go for arbitration or any other ADR system to avoid the killing of the product to time into the court of room, because court are generally non-product predictable in India, and even the time that you spend in the court will have uncertainty and all those things. Therefore, the person who are dealing into the IPR don't generally want to enter into the courtrooms for their litigation. They wanted to have the compromise outside where the win-win situation can be arises. Therefore, I have concentrated on this particular things. Few things I again just wanted to discuss. What the advocates who are wanted to have a good career into the IPR, they must know that they must know the registration technology, how the rights can be arises, how bundle of rights can be gained from the authority. Suppose, for example, patent is there, how can they just secure the priority date, how they can within time file their complete specification. Generally, drafting of patent is very technical and it can be done only by the patent agent. And generally, advocate having not having the background of science can be the patent agent. Therefore, this job is to be assigned to the patent agent. They will draft it, and once you are able to capable to get patent, how you can keep on watch that there should not be any litigation. And more important is that how you can spread your patent throughout the globe, throughout the different jurisdiction, how you can enter, allow the company, facilitate the company to enter the different jurisdiction, and with the documents that they can protect their product into the different jurisdiction, sell it. Because IPR product is like just like a food. Better one time you can serve, you consume it. You may not be aware. Suppose, for example, take for example the mobile technology. It is hardly for 1 year, hardly 2 years, new technology will replace the old technology. Therefore, if you invent something today, exploit it as much as you can, as quickly as you can. Nowadays, take for example, when the good books has been written in 19th century in Europe, it will require 10 years to 20 years to come to India by ship. Now, within a fraction of second, you can transfer the content of that book from one destination to other. Any digital content that has been created capable to be exploited as quickly as it can. Therefore, all IPR product must be consumed as early as you can, because there is always a threat that your competitor will come up with incremental advanced technology and your product will be get replaced by advanced technology. You are aware about the Nokia. They were having once dominated the mobile company. New company entered with new technology, Android technology, and they have replaced this Nokia. And therefore, you don't know that how much life of this IPR, though the authority has given the specific protection of one product for several years, you may not be aware that how much your product will lie you into the market and how better technology, better product will replace your technology. If suppose, for example, today you are having Nokia dominate, Samsung dominated by good technology, tomorrow somebody else will come and they will dominate and they will replace these particular things, because nowadays the invention, the trademark, everything is now totally not very certainty is there into the market. Therefore, if you are holding IPR, you must be capable to be exploit commercially as fast as you can, and better you take this decision. More particularly, you enter into the better jurisdiction with the help of good agreements and all those things. You will grab more market, and if you grab more market, then you will be more stable into the market. Therefore, once you are having the IPR product, as early you can go for production and consumption protection of these and spreading this particular product, making more consumption of this product into the market, protecting it better way, and going as early as you can by grabbing the market and as much as you can. Therefore, this particular things, I feel that in IPR, any advocate must know. If the advocates are only confined to the knowledge of these particular things, that what are the IPR and all these things, better than you must know the reality. Sometimes even taking 2 steps back for an advocate is advisable. But sometimes even entering into the any such jurisdiction with very low royalty is also advisable, and you must allow and facilitate such type of licensing, assignment, and all those things, and bind different people by different clauses. So the role of legal practitioner with regard to the IPR is totally a different one, and that he must be aware that what is the exact role he can play. He may be aware about the content, but better he must be aware about the jurisdiction. Sometimes the Western people do not want to invest in India, not because they are not aware, but because they feel that the Indian courts are very lethargic in giving the protection to their product. And with regard to the IPR solution, the Indian court are not better to give best remedy for them, and therefore they do not want to enter into Indian market with their technology. And while transferring the technology, they are skeptical most of the time. And these are the things nowadays, for advocates, they must know all these things, that how the protection of technology, sharing of technology, exploitation of technology, consumption, and all those things, customers' interest, all these things must be there into the clause. Indemnification clause is also very one good things. Arbitration clause into the agreement is always advisable. Then there are so many such things are there. You must keep your product alive, you must pay the renewal fees, you must keep on complying all those things which is required, because under patent act there are several conditions after the grant of patent to be get fulfilled. If you do not, after getting the patent, satisfy the interest of the society, the compulsory license can be granted by the government. Therefore, advocates should also be advised to keep watch one clause on compulsory licensing, that any sub-licensor should also take care that the interest of the society may be served, otherwise Section 84 of the Patent Act will get implemented, and the compulsory licensing against the company, against the patentee, against the holder of the patent will be granted by the government. So such type of clause, keeping in view of the IPR, the advocate must know. The role of advocate lies from this point of view. Rather than knowing the entire concept of IPR, he must know how to protect IPR as a product. So this is what I can just tell about these things. If anybody is having any query, we can just discuss on this particular point.
Okay, we are taking up the questions. If participants have any question, please ask one by one.
Sir, I would like to ask a question. Sir, as we all know that there is a shortage of vaccine right now in our country, particularly of the co-vaccine. And the point related to co-vaccine is related to the government agencies. So according to you, what are the reasons behind the problem with the government, that why the government is not handing over the formula to the other companies so that they can also manufacture the product so that the public welfare can be done? What are the problems in that field?
Yes, sir. Thank you, Barak, sir. I think that you are having the business law as your specialization. I have gone through your biodata also. The important things at this stage with regard to the vaccination is concerned. See, the production itself with regard to vaccination, there are several issues are there. For example, see, when the co-vaccine was started to get prepared, or suppose, for example, Covishield, that was Serum Institute of Pune or this Bharat Biotech, they are going to prepare the vaccine. At initial stage, they are going for the clinical trial. At that time itself, there are several things that was going on. Means when they have started the clinical trial, several commercial contract has been, or demand has been placed by several companies and several government also. Try to understand these things. Now suppose, for example, what we have done was that Serum Institute was pressurized by one of the political parties that they should supply their Covishield to the Indian people first. But try to understand that in September, October last year, when the Serum Institute was about to prepare and going for clinical trial and getting the approval from the government, they started one. Several companies and government itself, a foreign government, has placed their order for the vaccine. If that vaccine would prepared by Serum in future, they must give certain quota or this much demand they must fulfill. That is called as a commercial liability coming out of that contract. And at the same time, there are certain obligation on this company to provide 10% of their production to the local government. Now Serum has given 10% of their production to the government, but 90% they are having commercial obligation to supply those governments or those companies who have placed their orders from outside the company. Try to understand this aspect. Similar things with regard to the co-vaccine also. They are under compulsion because this contract was initiated even at the time when the vaccine was not coming to existence. So such a type of contract was only going on with very initial stage, and this company are under obligation that if the successful vaccine will come out, you will take the example of Canada. Now Canada is having in such a position that they will, as they have entered early into this contract, that the company who will prepare the vaccine must supply their vaccine to their nation. They are having 10 times quota than their population, because that country has taken very initiative at the initial stage. Unfortunately, you will see that why Serum Institute are claiming that they cannot supply to the government, because initial stage the government of India did not place their order. You just ask and go for asking to the government of India whether they have placed their order at the initial stage to how many companies, so that when the production will start. Now I have already told you, suppose I am having IPR product and suppose I need 6 months for its production. My product is approved at initial stage that it is good one, and after 6 months I will get probably the first dose for that. I will enter into contract from this particular stage itself, because in future I need amount for that. I need certain seed amount for that. I need to have the good market for that, all those things. And this type of game, this type of litigation, this type of agreement are always going on into the international market. And therefore, as you already told, that though Covaxin, that Bharat Biotech, they are also bound to supply to India, but only the quota of 10% because they are locally placed company. But what you are telling about the health hazard and all those things are there. If you go and read section 93 or 87 onward to 93 of the Patent Act, you will see that such a type of things arises only in special circumstances where you can see that there is nothing is possible to be drawn up and government wanted to acquire that particular things. Biotech is preparing their product according to their capacity, and there is not yet any fault has been arises with regard to their production capacity. The problem is that the requirement is more, and you cannot blame the company because company they can overnight cannot create the havoc and prepare the thousands of bottles in a day. Thousands of vials cannot be created if their capacity is hundreds in a day. Therefore, that is their limitations also. And problem is that now, if you see that now government has started placing order, they are saying that after August they will get special stages. They are capable to get this much of drug and 92 crores of vial they are capable to get by December 2021 because late initiative by the government and late placement of an order. That is the problem. If this government would have taken the initiative, this company would have been positioned to provide the supply that much of that production percentage to the government of India. Right now, government of India is getting 10%, out of which, out of certain international obligations, they are supplying to the poor countries, and remaining one they are using in India only, but that much is very less dose as compared to that. But after August now, they have already placed the order, and I think that the situation will get improved after August only with regard to the supply of these doses. And similarly, in market also, if the production is more and different the vaccine will come into market, definitely we will get vaccinated. But so far as IPR is concerned, this is the game. Now I try to understand that why other Poonawalla has been to Britain and what was his statement. He was saying that people are pressurizing us, but they are under the commercial obligation. And you are trying to understand that suppose India is there, India enter into the contract with any foreign company. And if that foreign company, under the pressure of their local politicians, refuse to supply to India, can they do that? Under international obligation, you are also bound by certain contract, and under contract act, you have to fulfill your obligation. And therefore, there is a statement that one particular local politician from Pune has made a call to them to supply first to India, and they are under this commercial obligation because they have entered into contract well prior to the production at the stage of clinical trial itself. Because one of my student is doing research on clinical trial, and one person was living into the same flat scheme where she is living. So she was having all these things that we came to know that this country has having the contract with Serum Institute, this company is entering into contract with this one, we are going to prescribe this, that only. This situation was not speculated, I think, by Indian politician in September, October 2020. Anything else?
Next question.
चौबे साहब आप प्रोडक्ट एंड प्रोसेस के बारे में थोड़ा बोल दीजिए।
हाँ सर थोड़ा सा बता दूंगा। वो सर ऐसा है, अर्लियर द इंडियन पेटेंट एक्ट, मैं थोड़ा सा पीछे जाऊंगा। 1970 में जब नए टाइप का 1970 में पेटेंट एक्ट आया, उसके पहले था 1970 में इंदिरा गांधी हैज टेकन इनिशिएटिव, और इंडियन पेटेंट एक्ट में 3 अलग अलग इंडस्ट्रीज को प्रोटेक्ट करना था। तो एक एग्रीकल्चर यूनिवर्सिटी, एग्रीकल्चरल इंडस्ट्री, देन फूड इंडस्ट्री एंड फार्मा इंडस्ट्री, ये तीनों को प्रोटेक्ट करने के लिए एक नया इनोवेटिव आइडिया ऐसा लगाया कि इन तीनों एरिया में we will go for the process patent, we will not give the product patent. अब इसका गणित, इसका इक्वेशन इस तरह का है कि अगर मेरे पास एक प्रोडक्ट है, मान लीजिए मुझे चाय बनानी है, तो मैं अगर पूरे चाय या तीनों प्रोडक्ट के ऊपर पेटेंट लेके बैठ जाऊं, मैं मोनोपोलाइज कर दूं, एकाधिकार कर दूं सब पर, चाय पर, दूध पर, पानी पर और शक्कर पर. Now nobody can prepare the cup of tea for anybody. They have to come to me, and I will have the good market. I will grab all the market. तो एग्रीकल्चर, फूड और मेडिसिन, ये तीन एरिया को बचाने के लिए इन्होंने बोला कि नहीं, हम प्रोसेस पेटेंट देंगे. हाउ टू प्रिपेयर कप ऑफ टी, दैट वी विल प्रोवाइड. तो ये प्रोसेस पेटेंट का जमाना शुरू हुआ 1970 से, 72 से एक्चुअली अमल में आया. प्रोसेस पेटेंट के लिए सेक्शन 5 नया इंसर्ट किया था पेटेंट एक्ट में. 3 अलग से था, 3 में था व्हाट इज नॉट पेटेंटेबल, और कुछ प्रोडक्ट ये पर्टिकुलर इंडस्ट्री में, 3 इंडस्ट्री को बचा के इसमें सिर्फ प्रोसेस पेटेंट देंगे. Therefore, suppose you are having paracetamol drug, so if I am having the monopoly over the paracetamol drug, I will not allow anybody to use that drug. लेकिन अगर प्रोसेस पेटेंट होगा तो पैरासीटामोल में कुछ और मिला के, पैरासीटामोल में एलर्जी कुछ और भी मिला के, आई कैन प्रिपेयर द ड्रग फॉर कंट्रोलिंग द टेम्परेचर ऑफ द बॉडी. तो आई कैन हैव द 10 डिफरेंट टाइप ऑफ मेडिसिन फॉर पैरासीटामोल, एंड देयरफॉर इन मार्केट द प्राइस विल बी वेरी लो, people are capable to get the drug at low cost. तो एक ही ड्रग, लेकिन उसका प्रोसेस को ही सिर्फ पेटेंट है. अगर प्रोसेस ऐसा है कि 3 ड्रग मिला के एक ड्रग बन रहा है, एक मेडिसिन बन रहा है, तो दैट प्रोसेस पेटेंट इज ओनली कैपेबल टू गेट पेटेंट. नाउ इन इंडिया देयरफॉर फार्मास्यूटिकल इंडस्ट्री का आज जो पूरे वर्ल्ड में डोमिनेट हो रहा है, वो सिर्फ इसी वजह से कि 1970 में प्रोसेस पेटेंट की वजह से बहुत कंपनी आई, और डिमांड सप्लाई के अंदर दे आर आल्सो कैपेबल टू बी produce better drugs, and there was no any monopoly on a specific drug, only the process was patentized. Therefore अगर आप सिर्फ प्रोसेस को ही पेटेंटाइज करते हैं, प्रोसेस को पेटेंटाइज करते हैं, तो लोगों के पास ऑप्शन होता है दूसरे इंक्रीमेंटल ड्रग और अदर कॉम्बिनेशन को ट्राई करने का, and therefore that way the industry was grown up. The same thing also है, ऐसे ही हमारे एग्रीकल्चर प्रोडक्ट के बारे में भी हुआ कि हमने एग्रीकल्चर इंडस्ट्री को बचाने के लिए सिर्फ प्रोसेस पेटेंट को बोला कि प्रोसेस पेटेंट विल बी अलाउड, वी विल नॉट अलाउ एनी अदर. सेम थिंग इज विद रिगार्ड टू द फूड. नाउ इन 1995 वर्ल्ड ट्रेड ऑर्गेनाइजेशन हैज कम अप विद वन ट्रिप्स एग्रीमेंट, ट्रेड रिलेटेड एस्पेक्ट ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट्स. So that particular TRIPS agreement has made it compulsory that you must have the product patent. और अगर आपको कोई स्पेसिफिक छूट देना होगा तो वो ऐसी छूट दे सकते जो कि illogical ना लगे. And therefore under the obligation of that particular TRIPS agreement, because we have opted to enter into WTO agreement, and TRIPS agreement का article 1 ये कहता है कि if you wanted to opt in, अगर आपको हमारे अंदर आना है WTO के ट्रिप्स एग्रीमेंट से, तो यू हैव टू मॉडिफाइड योर इंटेलेक्चुअल प्रॉपर्टी लॉस, एंड देयरफॉर आफ्टर 5 इयर्स ऑफ ट्रांजिशन पीरियड 2020 में हमने प्रोडक्ट पेटेंट का ही ऑप्शन रखा. प्रोसेस पेटेंट नाउ सेक्शन 5 ऑफ द पेटेंट एक्ट हैज बीन डिलीटेड बाय 31st December 2000 because that was now against the TRIPS agreement, and we are compulsory have to opt or comply with the TRIPS agreement. तो आप अगर देखेंगे अभी पेटेंट एक्ट में, तो सेक्शन 5 को देखेंगे तो सेक्शन 5 इज नाउ डिलीटेड, एंड प्रोसेस पेटेंट का अब नहीं रहा. लेकिन प्रोसेस पेटेंट ने हमारे कुछ इंडस्ट्री को रियली बूस्ट अप किया, एंड देयर वाज वेराइटीज ऑफ द ड्रग्स अवेलेबल फॉर द पीपल बिकॉज़ देयर वाज नो एनी मोनोपोली. और ऐसा ही मोनोपोली, जैसा अगर आज हम वायल बनाने का प्रोसेस पेटेंट कर दे और उसमें एक आधा नया कंटेंट बना के दूसरा कंपनी आ जाए, तो देन वैक्सीनेशन में पॉसिबल हो सकता था. बट नाउ बिकॉज प्रोडक्ट पेटेंट इज ओनली अवेलेबल, दैट प्रोसेस कैन नॉट बी हाईजैक्ड बाय एनीबॉडी, एंड यू कैन नॉट मेक थिंग्स. ओनली वन थिंग्स अवेलेबल विद इंडिया इज नाउ विद द जेनेरिक ड्रग. हम जेनेरिक ड्रग को प्रोटेक्शन नहीं दे रहे हैं, लेकिन जो प्रोडक्ट बना रहा है, प्रोडक्ट पेटेंट इज नाउ द ओनली वन ऑप्शन रिमेन इन India. So you can see now section 5 of Patent Act 1970 has been deleted from 31st December 2000 for complying the TRIPS agreement, that is we enter into 1995. तो ये प्रोडक्ट पेटेंट और प्रोसेस पेटेंट का ये फर्क था, जो कि अब इंडिया में नहीं रहा। हमारा एक यूनिक फीचर था वो हमारे पेटेंट एक्ट में, वो अभी हमने निकाल दिया है। लेकिन फिर भी कुछ चीजें हमने अपने पास पे रखी। कंपल्सरी लाइसेंसिंग का उधर डाल के रखा है कि अगर आप करना चाहे तो प्रोडक्ट पेटेंट ले लीजिए, लेकिन अगर आप 3 कंडीशन फुलफिल नहीं करेंगे, इट मस्ट बी प्रिपेयर इन इंडिया, इट मस्ट बी मेड रीजनेबल प्राइस एंड मस्ट बी अवेलेबल फॉर सेटिस्फेक्शन टू द सोसाइटी. If you are unsatisfied to fulfill any of this condition, any company come forward for the preparation of that drug or compulsory license can be given to that company. अगर कोई ये प्रूव कर देता है कि 3 साल के बाद के अंदर अगर समझो पेटेंट ये कर नहीं रहा है, तो इंडियन गवर्नमेंट हैज स्टिल फुलफिल्ड एंड इन स्पेशल सर्कमस्टांसेस ऑफ हेल्थ हजार्ड सेक्शन 87 से 92 तक कुछ राइट्स गवर्नमेंट ने रखे हैं कि हम उसका लेके गरीब कंट्री को भी दे सकते हैं। हेल्थ हजार्ड को डील करने के लिए वी कैन टेक एनी इन्वेंशन इन आवर हैंड, दैट इज विद रिगार्ड टू इंडियन ग्रांटेड पेटेंट बाय इंडियन गवर्नमेंट ओनली.
Okay, थैंक यू.
Thank you sir.
Okay. Next question. Okay, I believe there is no more question. Thank you, sir, for giving us insight into the legal aspect of commercial management of IPR. And I believe this will go a long way and will be helpful not only for our students, but for the other people practicing in other profession as well. Now, I would like to request our director, sir, Professor Dr. Binayak Patnaik, to address the audience.
Very good afternoon to all of you. Honorable Chief Guest and Speaker, Professor Dr. Vijay Kumar Sri Krishna Chaubeji. All the honorable members of the trust, the patrons of this webinar, the principal of the institute, Dr. Bairagi, behind the screen, Rakesh Yadavji, Ashish, all my faculty members, and my dear students. Today we listen to Professor Chaube. So after listening to him, only one conclusion I have reached, that his lecture was highly informative and educative as well. It was very comprehensive and exhaustive. It was presented in a very simple way and we could easily understand. So on behalf of Shri Vaishnav Institute of Law, I express my profound sense of gratefulness to Chaube sir, that who immediately agreed to my invitation to deliver a talk, and today he has very nicely presented all aspects of intellectual property right. All of us know that intellectual property right is a broad canvas. It is very difficult to complete everything within this short duration. And I'm thankful that Professor Chaube, at least in outline, enlightened us everything, something about everything. We can say in certain aspects, he has dealt everything about everything, particularly in respect of copyright. And one thing which he told, it is very, very important, that sometimes we don't go for a registration because it has become very costly. We want to go for a even secret also, secret trade. Don't go for registration at all, because every time the technology is changing, the process is changing, the product is changing. Though whatever things you today say that you have an exclusive right, that right has no value in the market. It is replaced by some other thing. Therefore, very importantly, here you have said that unless and until your product or your invention is of some quality and at least can continue in a market for a long duration, it is better that you go for a registration. Anyway, as I always understand that we have no right to property. We have no absolute right to property, because whether it is a material property or intellectual property, it is only a legal right. To that point, which I would also like to ask, can the government also say, in the interest of the public, that he can take away that particular invention and make use for the public interest? Because the right whatsoever is not absolute one. Government can take over that right at any time, and he may offer you some amount as a, not compensation, some amount he can give you. Can this be possible in case of inventions? Chaube sir, since intellectual property right is also, hello, hello, hello.
I think Dr. Chobe is not in the meeting right now.
Acha.
Yes.
Anyway, so it is also a question which is to be taken up by everyone, that it is a only legal right. So the government can take that right at any point of time. And the second point is more important point, that one cannot monopolize the right. And you should always allow for competition. If anybody comes that you have violated, and he will say, no, it is not a violation, you can't say like that. We must give rise to competition also. One should not monopolize any right. And last but not the least, it must help in the scientific progress. It must help in the protection of the social interest. So only one thing I will say, though, even though that intellectual property right is a right in rem, still you have no absolute right on your intellectual property. That is the conclusion. Like property. And always it must satisfy human right, human dignity. So at the cost of human right and human dignity, one cannot do anything. So this is the conclusion of my conclusion of this particular topic. So I am thankful to Professor Dr. Chobe. I'm thankful to all the members of the faculty, principal of the institute, and all the students who have actively participated in the webinar and must have been enlightened by the delivery of Professor Chobe. I think Professor Chobe, let Professor Chobe come. Probably he has, for some time he has left or some problem occurred. Rakesh ji? Hello? Any problem? Any problem? What happened to Chobe sir? In any disconnection?
सर वो मुझे नहीं पता सर, उन्होंने लेफ्ट कर दिया होगा, मेरी साइड से कुछ भी नहीं है सर, प्रॉब्लम
नहीं है। तो
उन्होंने लेफ्ट कर दिया होगा, तो ज्वाइन नहीं करा वापस, सर ज्वाइन करते तो फायदा नहीं।
So at this point, we will wait for a few moments. I will call Chobe ji. Sir, you have left the meeting. So should we wait, sir, for you? We will wait for some minutes. We will wait for some time. Sir, we will wait for a few minutes because there was a power cut. So he is coming. He is coming.
Hello.
Ah,
Good morning, sir.
okay, okay, sir.
There was power failure, sir, at my home. Therefore, I was forced to get new that meeting.
No problem, sir. No problem.
Ji.
Now it is all right.
Okay, sir.
Sir, what I was talking, sir,
Yes, sir.
the right to property is only a legal right.
Yes, sir. Definitely.
So nobody has got the monopoly right over the intellectual property right also.
Yes, sir. Yes.
Can it be possible that as far as we're discussing, can government say either to the company that we will give some amount and he can take away that particular right?
No, sir. Even with regard to property rights, means even land and other things, compulsory acquisition of that land is also the one kind of specific right that government can enjoy as a sovereign right. They can compulsorily acquire your land and give you the compensation. Similarly, government can claim over even your intellectual property right and compulsory take it. The similar kind of provision has also been provided under copyright and patent right also. Means under compulsory licensing and government under section 93 even under property right. If you do not wish to publish any book that is out of stock, government can take forcefully that book and they can publish it and pay you the royalty, reasonable royalty to you. So such kind of procedure, because see sir, the intellectual property right, that the balance should be maintained between the social right and individual right, as we have been taught under the sociological school of jurisprudence.
That's I told that. It must protect the social interest and human dignity.
Because see, once if your personal interest override over the social interest, the government come to play their role to compulsorily acquire whatever in benefit of the society and give it to the society as they feel fit. The similar thing, suppose for example, you are having the drug for with regard to HIV and you do not wish to share that drug, the government is forcefully take your that particular things in social interest.
No, I'm talking of the vaccine.
Vaccine, about vaccine also that can be done, but at the same time you have to the situation must be like that ki you are not able to provide it. Here the problem is that capacity of the company itself is not like that. That is the problem. Means here the company is not at all fault. They have not speculated such much high demand from the society itself, and they are not at failure. Meanwhile, they will improve their production also, but reasonable time they must be also given. Otherwise, it will be the thing that you are playing with their right unreasonably. Means they must able to prove that that is their fault that they are not providing the vaccine. In fact, they are doing well. Problem is that they have not speculated such much high demand of the drugs vaccine at a specific moment of time.
Yes, yes. And the government can also take, you cannot export.
Yeah, definitely. No, sir. Problem is that initial stage government can do only in such a circumstances, and government then what about if other government also do not supply you the raw material? Because whenever this commercial contract at international level takes place, there are several other issues also involved, because America is giving the raw material for this manufacturer only on condition that they will also provide them the vaccine on such conditions.
The finished product they have to supply. The finished product.
They will not provide them the raw material. Then what would be the alternative you are having? And at such stage, if you do such things, what would be the reputation of the Indian government that the company situated in India is not capable to be believed? And because one particular problem was there, before 1991, people did not used to or dare to invest in India because we are having socialistic structure. When we open our market, then only the foreign company come and able to invest and willing to invest in India, because they also want some assurances. If you started doing such things, the company, that international community will also stand against you, telling that you will do such things, and then we will also doing the same things about your own population also.
Yes. Okay, thank you.
Thank you, sir. Thank you.
So, sir, the matter now has come to an end. And,
yes, sir,
and on behalf of Shri Vaishnav Institute of Law, we express our deep sense of thankfulness to you, sir, for accepting our invitation. This is second time you have come, and without any hesitation, ungrudgingly, very in a great pleasure.
Sir, you are our mentor, sir. Why you are telling this? You just order.
But within a short time, you have produced a number of PhDs. So that is a very remarkable achievement you have made in your life.
Yes, sir. Thank you.
Very short duration, 17 PhDs.
Yes, sir. Yes, sir. Now in September 4 are again due, but I don't know how whether they are going to submit it or not. But sir, that subjects are a variety of subjects. The PhD has been produced. One is on clinical trial that is going on recently. That's adultery. My one student has submitted in 2016. The same 497. The judgment was came in 2018. Subject internal migration. I have told you biomedical waste management, where one of your article has been taken as the most powerful guideline for that particular things. Biomedical waste management.
Okay, sir, we may also, because you are specialized in a number of areas, we may take you may take your help also in future.
Sir, you just order me, sir. You are our mentor. Myself, Shila Ram Sundar sir, and all those.
Okay, sir. Thank you, sir. Thank you very much.
I think that Behrampur University has produced number of scholars as compared to my university. Still
that is there. But in a very long run.
Definitely, very good department was there.
Long run. In a long run, they produce, but not in a very short time like you, like a young person like you.
Yes.
Anyway, we are very thankful to you, sir. And
thank you, sir. Thank you. All faculty members for listening me patiently.
Oh, everyone is happy. And we have also a very minute discussions also on very important areas. Thank you very much. And Namrata?
Yes, sir.
Please announce for the closure of the meeting.
Okay, sir. So thank you everyone for listening patiently and for making this webinar successful. I hope everyone is well and please keep yourself safe and your family safe. So the webinar is over. Have a nice day. Thank you.
Okay, sir. Thank you.
Thank you, Namrata. Thank you. Thank
Thank
you,
you.
Director sir, all faculty members
Okay. Okay.
participants.
Okay, sir.